Ready?
Yes.
All right. Call to order. This is the regular meeting of the Compliance Amendments Committee of the Sunshine Ordinance Task Force. The date is February 17th, 2015, and the time is 4:06 p.m. If we can have the roll call.
On the call of roll, Member Copra? Copra absent. Member Washburn?
Present.
Washburn present. Chair Hepner?
Present.
Hepner present. We have a quorum.
All right. And are there any agenda changes to our regular meeting this evening?
There are no agenda changes.
Okay. Then moving on to agenda item 2.
Item number 2, adoption of the December 16th, 2014 Compliance and Amendments Committee meeting minutes.
I move to continue these minutes. The reason I'm asking that they be continued is that in reviewing them, it appears that at least, I guess it was item number 6, was a hearing that was held with us acting as the complaints committee.
It was placed on this agenda because there was an associated file. I believe one moment. Item number 7 is a related file. Therefore, I placed both items on this agenda. I did not create a separate complaint committee agenda for Mr. Gold's item since it was associated with 14026, which is item number 7.
So back in December when this committee met, we didn't first meet as the CIC and then adjourn and then reconvene as the complaint committee.
From my recollection, we did not do that. I can double check. I do not believe there was.
That's my recollection as well, is that we took them as all part of the same agenda on December 16th.
Okay. Well, then, then there was only one agenda, then the minutes are the minutes for one meeting.
Yes.
And you do indicate that that particular item was a complaint that was heard.
Yes.
Okay. We found jurisdiction and all the rest. Okay. Then I'd like to withdraw my motion and move to approve the minutes.
Okay, second.
Is there any public comment regarding the minutes for December the 16th, 2014? There being no public comment.
Okay.
On the call of the roll, Member Copra absent. Member Washburn?
Aye.
Washburn, aye. Chair Hepner?
Aye.
Hepner, aye. The motion passes.
So moving to agenda file number 3.
Item number 3.
Item number 3, excuse me.
Item number 3, update, file number 14094, Arts Commission Procedures and Policy Review. I have attached my update regarding this matter. In regards to portion 1 of this item, regarding this is regarding the posting of agendas, minutes, and audio recording. I have been monitoring them for the past 3 months, approximately, and upon my review, all agendas and minutes have been posted as required. I have provided the following suggestion to the Arts Commission that they insert on the bottom of the page, post-it, date and time, and initials.
Can I ask a quick question there? Are audio recordings and minutes of subcommittees up to date and being posted right now?
Yes.
Okay, all subcommittees that we know of?
Yes, I believe at the last meeting of the Sunshine Orange Task Force, we did hear that order of determination, and it was determined that all their minutes were online.
Okay. Including subcommittees, which they they're taking the position that they do not have the obligation to post those currently, but are doing so anyway.
Yes.
Okay.
There will probably be some debate at our 4:30 hearing regarding that issue.
I think so.
I asked that they add the time of posting also as just to ensure that they're being posted on time. Over the past month, the format of this posted date was unpredictable. So they have agreed to use that format. Number two, I requested a minimum that the minutes, a draft version of the minutes be posted within 10 working days. The Arts Commission has complied with that request, and I have verified that. Item number three, this is the issue we were just speaking about regarding the courtesy posting of agendas, minutes, and audios for the subcommittees of the Arts Commission.
Right, and I just want to make sure it's clear that we have not apparently arrived at a final determination regarding whether subcommittees are subject to that requirement, but that is, as you indicated, going to be the debate of an item on our 4:30
Yes.
agenda, or the complaints agenda, rather.
Regarding public records request, under item number three, I did make a recommendation that they create a central email address for all incoming public records requests and complaints. They have agreed to do that, and listed on my letter is the email address they have created: sfac records request at sfgov.org. I did want to suggest that they take steps to publicize that and ensure that it's on everyone's out-of-office email. Item number four, other issues.
Okay, we skipped items number 1 and 2, but I suppose...
That's just a summary of questions previously asked that there's really no answers.
Right, and I think that with respect to item number 2 in particular, that seems like something we're going to have to address on a case-by-case basis unless we attempt to add some reasonableness standard to our, consideration of complaints. I'm not really sure how to address that right now. Okay, and then now item number 4 is other issues, and did we receive a written response from the respondent from the Arts Commission with all supporting documents, recordings?
Regarding 4A, the formats, they did provide a draft of their policies and procedures.
Okay.
However, we are currently putting out, discussed at the last Sunshine meeting, my current outgoing email to the respondents, when I first send them the complaint, I have a list of 4 items listing how we want them to respond, date of response, how you answer the question,
Right.
and so forth. I will provide a copy to you next chance I get. Skipping over items to item 4B, process for handling repeats of the same request. I, as the administrator, am currently reviewing the complaints that are incoming and rejecting complaints that are a repeat. We've had 1 or 2 from complainants who are trying to file on the same issues after we have made a decision, and I have not been accepting them.
Okay. And what process do you use to distinguish?
It is very clear when it is a repeat. Just send a sample. Mr. Jason Grant Garza, he's filed complaints in the past concerning medical records requests on specific dates. He just filed another one on the same dates, new request. So I am tempted to deny that because we have already adjudicated the matter.
So do you, through the chair, so do you state in your letter that, and ask if, or do you ask if there's any new facts and evidence that would warrant a reconsideration? Or I know we have a procedure for somebody can appeal a decision that we've made or ask for reconsideration, but
They
this
can
would be
appeal an order of determination,
right.
but not a findings of no violation. So that would be a possible another change to our complaint procedures.
So this would be for okay, so if we do find a violation, then the respondent would be able to appeal that. So
Yes.
the flip would be we find no violation and the complainant could ask for reconsideration.
Yes.
So do you indicate
If
to
there
the
is
new
new
app-
information or a new complaint, then I do contact them. I don't deny it without asking questions,
Okay,
but I do tell them it is the same complaint. We're not going to re-adjudicate unless there's some new information or new complaint.
okay.
And a lot of times I'll create a file and I'll put it on my administrator's report and let the task force make that decision.
Okay.
Unless it's very clear, I don't make the decision on my own.
I'm sorry, I just want to go back to 4A.
Yes.
I think I'm just a little confused, but I may have it actually. This language, this additional language.
I did list it, sorry. That is a new language I'm putting in all my outgoing emails. When I first receive a complaint, I send the complaint to the respondent, and I am including this request with my letter to the respondent asking them to provide an explanation of how they responded to the complainant's request.
Okay. And then the other that's what I figured it was. Thank you. And then the document that was attached to this agenda item is the San Francisco Arts Commission Sunshine Log. Was that submitted by you, Victor, or was that?
That was submitted by the Arts Commission.
Okay.
At my request. I wanted to, this was something that the task force found useful at the last meeting, so I wanted to get an update version for your review.
Thank you. Yeah, and I think it's interesting. So I don't believe there's any motion on this.
There is no action for the task force to take unless there's additional questions you have for the task force or monitoring that you wish me to do.
Through the chair, I wanted to say that I've seen copies of recent notices you've sent to respondents for complaints, and I think what you've outlined here, your kind of boilerplate you're going to be using, will be helpful to respondents and ultimately helpful to us. And I hope that you'll include this in the packet for the full task force, so they know how we're operating. Thanks to you.
Thank you, Victor. Seeing no action on this item, we can proceed to
I believe the representative from the Arts Commission is here at this time.
Yes, and I'm wondering if it's prudent to get an update at this point, or rather to wait until we consider a complaint. I don't know that an additional update is necessary. We could do so. I would want to.
If you don't have any questions, may we move on to public comment for this item?
Yeah, why don't we do public comment for this item?
Hi, members of the complaint committee. I disagree with the administrator's report. Firstly, there are two subcommittees that do not post their minutes correctly. They don't post draft minutes. They the Street Artists Committee, which I put up on your screen, always posts minutes. It doesn't go to draft minutes, and then when it goes to the full commission and gets voted on, change to minutes. I have actually gone to the full commission 17 times and contested their procedure for posting minutes prior to them being voted on, and they've never changed it. So that part is wrong.
You mean they're not posted as draft minutes?
There never have been posted as draft minutes.
Okay.
Never,
Okay.
ever.
Okay.
And then the most distressing is the advisory committee. I can pull that up, which are a series of handwritten minutes that don't even meet the minimum standards of what minutes should be. This is a standing policy body meeting. They set criteria for screening for street artists, and these minutes just post as minutes also. They are never voted on and never come up before the full commission. So that has been that way as far back as the 1980s and has never changed. There's never been a date or time stamp on any of these, and in fact, what I explained to you at the last full task force, it was an hour before the meeting when the February 7th, 2007 minutes posted, and they were backdated. So owing to the fact that they don't work with IT, there's no audit of the minutes, and we have no way of knowing when these minutes posted. We are relying on one person for the cultural record and history of the city and county. And I can show you. So this is how you get to the minutes of this advisory committee, which is a very long-winded, complicated way, but they're handwritten. They don't reflect what took place, and there's no audio. You see, it's marked minutes, and there's never been a draft minutes. So in my view, owing to the fact that there is no audio, they've never apologized for their behavior, and basically they lost the cultural record for 2 years, I think this is a serious issue. And I think that they should continue to be on probation status.
Okay.
Thank you.
Thank you.
Good evening, task force members. Thomas Piccarello. I'm a little lost regarding agenda item 3. It says agenda item 3 would be Arts Commission's Procedures and Policy Review, presumably for case number 14094, which was an order of determination. So I think the Arts Commission needed to present to you what new procedures and policy reviews they have in place, rather than Mr. Young presenting for them. In addition to that, I've heard discussions about the Sunshine Ordinance Task Force policies and procedures under this agenda item. That doesn't seem to me to be proper. Let me just say, if you are going to give the right to the respondent to appeal, then you need to give the right to the complainant also to have the right to appeal. There shouldn't be a distinction as to appellate rights.
What is being appealed? I'm confused.
Pardon me?
Who is a...
I heard discussion on item agenda number 3. I don't know how it got involved on item agenda 3, but I heard Mr. Young say regarding appeal rights, it would be applicable to respondent but not complainant if the complainant lost. If there was no order of determination or no motion, then that complainant would not be able to appeal. And I'm suggesting to you that if you're going to give the respondent the right to appeal, the complainant also needs that same procedure in place. But more importantly, though, the discussion was on task force policies and procedures, and I don't know how that was put on agenda item number 3. Agenda item number 3 speaks just to the Arts Commission. What policies and procedures have they implemented since your order of determination? I would like to hear from the Arts Commission regarding that.
Yeah, I would like to hear from them as well.
Thank you.
Mm-hmm.
Is there any additional public comment? There is no additional public comment. Just to clarify, the file number is the file number of the hearing, and there's no complaint involved with this file number. File number 14094 is not a complaint, it is a hearing file.
Okay, and there is a representative from the Arts Commission present? And was that representative present at the time that we started with this update? I mean, I know that now it appears that we're taking things after public comment, but I do think it's relevant to hear an update from the Arts Commission itself, what procedures and policies are, what changes have been made, if any.
Good afternoon, Chair Hepner and Member Washburn. So my understanding from my conversations with Mr. Young were that we were responding to a memo that he authored and some questions that he raised. And I can happy to answer any questions at this time. I think he has provided a thorough update, and I don't have anything additional to add.
Okay, and then the Arts Commission's response is reflected in the update. Is that where the Arts Commission response to Mr. Young's memorandum is?
So the updates were provided by Mr. Young, and the document that we sent at his request is the update to the Sunshine Log, which is our same log. It's just being updated regularly.
Okay. So this memorandum by Mr. Young, Administrator Young, was not written by the Arts Commission. Does it reflect? I'm confused. You indicated that you were supposed to respond to this memorandum. Have you responded to the memorandum?
So we've been working with Mr. Young on all of
Okay.
the items that he raised, and we have addressed all of the items pertaining to us in this memo. Some of the memo does pertain to policies and procedures of the Sunshine Ordinance Task Force.
Okay. Well, if you have, thank you. And if you have nothing else to provide at this point, I assume we're going to dig a little deeper into some issues on the complaints agenda when that arrives.
Great, thank you.
And I don't think any action needs to be taken at this point, so why don't we move to the next agenda item?
We can either close this matter or continue to the call of the chair.
Well, I think that
File or continue, basically.
I think continue. It appears to me that there are still outstanding issues, and I would be unsatisfied closing this at this point.
On the motion to continue the matter to the call of the chair, if there... Member Copra absent. Member Washburn?
Aye.
Washburn, aye. Chair Hepner?
Aye.
Hepner, aye. The motion passes and the matter is continued to the call of the chair. Next on the agenda is item number 4, file number 14073, proposed amendments to the Sunshine Ordinance, section 67.29.5, calendars of certain officials. I believe that I did send a memo around stating that the Board of Supervisors, Supervisor Avalos, has submitted a similar ordinance for the Board of Supervisors Rules Committee to review.
Is it not the same exact language? Because I've been trying to follow
It looks
this.
exactly the same, but I believe...
And I think Deputy City Attorney John Givner wrote both.
I believe it's the same document myself, but
Okay.
I can't tell for sure.
Okay. And this is an item, I do find that development interesting because as we've been preparing to sort of approach the Board of Supervisors with how to effectuate these changes, it appears he jumped the gun on us, which is just as well. I would like to hear public comment on the language in here, and I have some particular questions rather for Mr. Nee, who used to be a member of the Sunshine Ordinance Task Force, because I know that Mr. Nee submitted a version of the language in here, and I wanted to get your opinion on what you think of the language that is in the current version.
Committee members, thank you for inviting my comment. I'm very pleased with the language for the most part. However, in the draft that I had originally submitted, there was some additional wording in there right at the top. What I had suggested was every elected official dash, including but not limited to dash, the mayor, city attorney, et cetera, dash, and every department head. The reason I did it that way is that it makes it much more flexible and inclusive. In other words, let's say if the language that you have before you is adopted, and then all of a sudden you have additional elected officials, dog catcher, garbage collector, whatever, and those names are not included, you might have a problem there. That's why I suggested the language the way I did.
Yeah, that's understandable. And I think that to the extent the current ordinance might be interpreted to require that supervisors already report their calendar requirements, it could have benefited from clearer, perhaps more inclusive language like that. And I'm not really sure. I think that's probably a recommendation that we can make to Supervisor Avalos' office and to Deputy City Attorney John Givner that we would agree with that language, but we would need to, of course, take a motion on it at the full task force.
As well as to the Rules Committee.
As well as to the Rules Committee. Correct. The other question I had here, I have a lot of questions about this ordinance, and I think that they kind of pertain to how it's going to be discussed at the Board of Supervisors and before the Rules Committee as well. What do you think of the limitation on anything that would constitute an unwarranted invasion of personal privacy? I'm curious where that limitation came from and how it might be applied or potentially misconstrued. It seems a bit ambiguous. I'm not sure what was intended there.
It is, I agree, maybe a bit too general. Ambiguous, I'm not so sure. I mean, there are plenty of laws that have that kind of language in them. Just for instance, the whole issue that's been batted back and forth about identifying people who submit petitions to a commission or to a department, and they don't want, and the department has withheld personal information about that, and then the task force has said, well, no, why are you withholding that information? And they'll say, well, it's guaranteed under the state constitution, right to privacy, and the task force's position has been not unless it's an unwarranted invasion of personal privacy or unless there is reason to believe that revealing this information would put the person to some kind of risk, safety risk. So, again, that's it is kind of vague, and you maybe it may open up some kind of a can of worms if that language is included. You might want to strike it. In which case you might run into some issues there with some members of the Board of Supervisors. They might ask why you're proposing to strike that particular portion of the language.
Right. I mean, I think where it raises a red flag is that it seems dependent on other bodies of law, but what constitutes a personal privacy? Well, what constitutes private information, and that is that question, I think, is constantly in flux.
Yeah. I would think that maybe it would already be covered in the whistleblower part of the language there.
Right.
Although I can envision circumstances where it isn't a whistleblower issue at all, and it's another matter that the meeting concerns, and personal privacy might be at issue. And I think it doesn't matter whether this clause is in here or not. If it's not here, it would be raised in certain circumstances. And I think having it here is probably a better thing. And it's always going to be a matter of interpretation, whether we leave it there or we don't leave it there. It's always an undercurrent and always can be raised as a reason for withholding some information.
Well, the danger there, I think, and I think this is the point that that Chair Hepner is making, is that if you leave that in there, public officials trying to keep certain information off of their calendars might use that as an excuse. And proving otherwise might be, proving that there was no such risk might be difficult. So, you're kind of dealing with a double-edged sword here.
Right. And then the other issue that I'm not really clear on, there seems to be an attempt in this language to identify what a meeting is for purposes of being reported on a calendar. And I think the logical inference is that this is about in-person meetings that take place between groups of individuals. But as as we become more digitally oriented in the way that we discuss things relating to public policy, is this inclusive of, say, a Skype meeting between 4 individuals?
My own, just off the top, I would say that would be yes. When you consider that the Brown Act and possibly the Sunshine Ordinance as well do permit electronic participation at a public meeting.
Right.
And so my own guess would be is if you have a Skype meeting, that is for the purpose of of conducting the official business of the city and county of San Francisco, regardless of whether it's enacting anything. It might be just for discussing some kind of policy or proposed policy. But if it's for the public purpose, if it's in the conduct of one's official duties and official business, then yes, I would say that the Skype example would be one that should be included.
And the same logic would extend to, say, like a conference call between several individuals that is scheduled to take place at 3 p.m. on a Friday, and we'll have these 5 or 6 people call into the conference call. That is a meeting that would be reported on the calendar?
I would say yes.
Okay. I mean, yeah, all right.
So should there be a clause in there that makes it clear that we would want to include in-person as well as virtual meetings?
I think virtual meetings is sort of what we're grasping at, right?
Virtual, whether it's Skype or GoToMeeting or Adobe Connect or whatever you're doing.
I mean, I think so, and I think that it's worth at least recommending to the people considering the final language of this to make it clear that by meeting we include, increasingly digital and not physically participation meetings where, not in-person meetings, should be included in this as well. And then, I had another thought regarding every elected official. There are a lot of elected officials that do not have, say, staffs that that necessarily would cover this for them, I mean, supervisors certainly have aides in their offices. The treasurer, assessor, recorder have offices that take care of a lot of the administrative work. What about a sitting member of the Board of Education or of the College Board?
Well, they're not covered under the Sunshine Ordinance.
So okay. So if we are to add language that says every elected official, we're implicitly saying every elected official who's already subject to the Sunshine Ordinance.
Yeah, or every elected official of the city and county of San Francisco, I think, would specify. But it would also Well, then port commissioners and airport commissions and so forth are covered by the Sunshine Ordinance, so they would be included, but they might be included under the rubric of department head. I don't know.
Right. Okay.
At any rate, it might make sense to say every elected official under the jurisdiction of this ordinance.
Okay.
I would certainly have no problem with that.
I'm wondering about the title of the section. It says calendars of certain officials. Should it be calendars of elected officials? Certain officials makes it sound like right off the bat it's not going to include everybody, and we're wanting to include everybody.
Well, again,
I guess no,
in the
department heads aren't
in the language that I initially proposed, I believe I suggested every elected official dash, including but not limited to, and then you list them, and then you have a dash, and then you say and every department head.
Right.
Okay.
But I'm just talking about the section title itself.
Oh.
Says calendars of certain officials.
Okay.
Should that read differently?
Should it read, for example, calendars of elected officials or
And department heads. Does that cover everybody?
Right, because this is a modification of an existing section.
And right now it's calendars of certain officials. It makes it sound like there are lots of officials that aren't going to be having to do this. And we're wanting to include all the elected ones plus all the department heads.
Okay. Well, I think that's another recommendation that we make to the full task force. Is that appropriate?
Right, so
This is scheduled before the task force on March 4th, I believe.
right. And when
So-
does rules meet to bring this, to consider this?
Just to answer Mr. Nee's question he provided to me via email, this matter was introduced at the last Board of Supervisors meeting. I believe it has been placed under the 30-day rule, so the Rules Committee will not be able to discuss it for at least 30 days. Once the Rules Committee does hear it, they can issue a recommendation to the full task force. Not the full task force, to the Board of Supervisors. The Board of Supervisors will have to have 2 readings on the matter before approval.
So we have time for this to go to our full task force and then
Yes.
for us to appear before the Rules Committee.
Yes, unless the President waives the 30-day rule, they will not be able to discuss it for 30 days.
Okay.
So let's assume that the president is not going to waive the 30-day rule. And let's, at the task force hearing on this, then, if we could make sure that they consider 3, I think I counted 3 items, and these are just issues to discuss, recommended issues to discuss from compliance and amendments. And that would be 1, whether the language in the first section should be modified to indicate that that all elected officials, quote, elected officials, including but not limited to the city attorney, treasurer, assessor, recorder, et cetera, et cetera, et cetera, and the mayor, and every department head shall keep, and then keep or cause to be kept a daily calendar, and that continues. The second issue, whether it is clear that virtual meetings such as Skype calls, conference calls are included in this calendar requirement. The third issue is whether the limitation on a limitation on disclosure of any information that would constitute an unwarranted invasion of personal privacy is vague or unnecessary. And I guess there is the fourth consideration of the title. Whether calendars of certain officials is sufficient, or whether we want that to be calendars of certain elected officials, or just calendars of elected officials, period, to be on the most inclusive end of that scale.
It should be calendars of elected officials and department heads.
Calendars of elected officials and department heads. Okay. So those, I suppose, are the 4 considerations that I would want to report to the task force for possible recommendation then, or for possible approval prior to bringing it before rules. Do we need to move to do that? Should we make a motion to do that?
I do not believe so. You can just present your recommendations to the full task force at their meeting.
Okay.
There's no need to make any official motions.
Okay.
It's already on their calendar, the exact same file.
And because we're not making an official motion on this, can we reserve public comment on this item until the full task force hearing on the
We should
matter?
still take public comment at this time.
Okay, let's take public comment on the item number 4.
Hello, Michael Petralis. First of all, if I heard you correctly, you said you did not get a heads up from Supervisor Avalos. I find that a bit troubling. For a number of years, the group known as the Sunshine Posse has been talking about this issue, and I'm really glad that it's come up finally at the Board of Soups. I think that Avalos is getting off to a wrong start by, first of all, not putting this draft language out there on the web that I could find, and also not giving you guys a heads up. That said, in this first section here where you're talking about with the exclusion of purely personal or social events, I have trouble with that. A social event would be a party at Twitter. If supervisors are going to parties at Twitter or concerts held by the guy who owns Oracle, I want to know about it. Certain social events we need to know about.
Wait, can I just ask you?
Let me finish my 3 minutes and then you can...
Oh, I think it would be paused. I just want to make it a little more interactive so that I understand what because the limitation on the next clause, it says, at which no city business is discussed and that do not take place at city office, at which no city business is discussed.
I am not going to trust an elected official to tell me no city business was discussed.
Okay.
I want to know they were at a party.
Okay. Anyway, you continue. I'm sorry for interrupting.
Thank you. Okay. On the next page, you're talking about for meetings, blah, blah, blah. Such calendars shall be made public, include a general statement of issues discussed. Let's go for minutes, or at least a summary of minutes. If they're telling us they discussed a Twitter matter and it says, we discussed a Twitter matter, that's not good enough. I want to know if you discussed Twitter's privacy policies regarding gays in China. We need a little bit more information there. And going on, it says, such calendar shall be made available to any requester 3 business days subsequent to the calendar entry date. I want it required that these public officials, especially the department heads and the soups who have staffers, they post this information on their sites within 3 days. I don't want the burden put on the public to make the request. I want the burden of making these minutes and calendars available put on the elected officials. And if it's going to be too much of a burden for each elected official to do that, let the city create a single website for all of these calendars to be posted. Thank you.
Thank you.
Thomas Piccirillo. I would agree with comments by Michael, Mr. Petralis, regarding the scopes of what needs to be put into the calendar entries. I am also troubled that we have 2 versions out here now. One was Supervisor Avalos and one by the Sunshine Task Force, drafted by the same district attorney, deputy district city attorney. I don't understand that. Maybe Mr. Givner could present to the full task force as to the different versions and what went on in that thinking. Specifically on the language, I agree with the change to all elected officials. That's more inclusive. If you look at the last 2 sentences on page 1, I would strike out the unwarranted invasion of privacy and interfere with an individual's right to petition government. I mean, that's vague and ambiguous, and it would fail if it was challenged. You could simply say that the disclosures would not be permissible if it violated any federal, state, or local law, period, without being specific. What is a warranted invasion of privacy that would be acceptable under your ordinance? Yeah, you should delete that language because it's vague and it'd be stricken if it was challenged, and just say the disclosures will comply with any federal, state, and local law, period. Thank you.
Thank you. Any additional public comment on item number 4? Seeing none. Does that conclude our... Oh, no.
May I, thinking about the matter, I believe that maybe there should be a motion to send the recommendations to the full task force. I can write up that the list of the 4 items and provide it to the full task force.
Well, now I believe that there might be a couple additional items that were raised by the public that perhaps should be discussed. And I don't know. I believe that we're supposed to make the motion before public comment, correct? So I don't want to get in a habit of doing it that way. Is there a way to just make sure that I thought
you can just provide a memo to the Sunshine Ordinance Task Force for their March 4th meeting.
Right. I don't think, and then we don't need a motion in order for this to be considered by the task force. And
no, it is already on their agenda.
Great. Okay. I think that's fine then.
Okay.
Okay. Thanks.
No action is taken by the committee on this item. Item number 5. Public comment. Members of the public may address the committee on matters within the committee's jurisdiction, but not on today's agenda.
Hello, Michael Petrellis again. I'd like to bring up the matter of airing these meetings on TV. I understand that the budget process is beginning with the mayor and all of the departments. I'm not sure if the task force or the clerk of the board puts together the agenda for the task force, but I think, again, we need to raise the issue of finding the money in the city budget to air at least the full task force meetings, maybe not every committee meeting on TV, but certainly when the full task force meets, I think that there should be a way to air those meetings on TV. And I've been going to the Fire Commission down at 2nd and Townsend since October. And let me tell you, it's a real schlep to get down to 2nd and Townsend to get to those meetings. They are this close to making a decision about allocating the money to air their commission meetings on TV. But one of the big sticking points is whether they're going to move from the headquarters to City Hall. You guys are blessed that the meetings are already happening here. So I think that is a selling point to whomever you have to go to as the budget process begins. Thank you.
Thank you.
I just want to let you know that I don't think I'm going to renew the street artist permit. It's been extremely eventful for me. All of it has been strange. It's been extraordinarily time-consuming. The last one was I got a 15-page letter over presumably pendant earrings, which really made no sense. I turned it into a PDF document. I supplied my response, how I made these things, yada, yada. There was no definition of what is the criteria, and so I sent it to the commission secretary asking for an acknowledgement. 2 weeks had passed. I didn't get the acknowledgement, so I personally walked it over there, and Howard Lazar would not let me in. I thought the commission secretary was directly about 30 feet ahead of me with somebody else. So I walked in saying nothing, handed it to her. She was mouthing off about how I'm banned from the office and the building. By the time I took the elevator and got downstairs to sign out, she was already down there ranting, accosting a total stranger who happened to be Pam Patterson of the Ethics Commission about how she should call the police. I have that on videotape. I spent 2 days at the management office, who apparently called down to an Ann Tricky, an office manager, advising her that her practices are bizarre. It's just one of the many ongoing things connected with these people. I don't know how they do business. I really don't interact with them too much, except to go out in the street and have these 45-minute inspections and get these long-winded letters which make no sense. For me, it's extraordinarily confusing, and I really don't see the point of renewing that permit. Thanks.
Thomas Piccirillo, I just want to comment on the absence of your third member tonight. His attendance is not acceptable. On your 4:30 special calendar, you're hearing 5 cases de novo, and they shouldn't be heard by just 2 members. What it's going to do, you're going to require unanimous, both of you are going to have to agree for the complainant in the situation that's presented when you have a third member absent. So I would encourage you to either incentivize Mr. Chopra to appear or replace him. It's not fair to the complainants who are in front of you tonight to have both of you agree for a finding of an order of determination, and you're recommending to the full task force. Thank you.
Thank you.
There is no further public comment. Item number 6, announcements, comments, questions, and future agenda items.
Right. I have a couple issues that were on the back burner for me, things that we could address here, the compliance and amendments. One was email retention policies, addressing email retention policy issues at the Board of Supervisors. I know that's something that we wanted to address, not necessarily in the context of dragging the supervisors before us, but to some review. And we were going to address that, I believe, with the clerk of the Board of Supervisors. I'm thinking it was file number, I wrote it down, 14047. We were going to at some point have an update on email retention policies.
I believe that was referred to EOTC.
Right.
It was, okay.
Right.
Just as well. And then the other, do we know when that's going before EOTC, off the cuff?
I will need to discuss it with their chair to see which items they would like to hear at their next meeting.
Okay. And then the other issue that possible future agenda item for us is following up with the city attorney's office about privilege logs, specifically, with respect to documents and communications withheld pursuant to attorney-client or work product privileges. And this came up in the context of a couple cases. One was file 14019. And I suppose it was just that one. But we had discussed, collaborating with the city attorney to the effect of the city attorney advising city departments that they may but do not have to withhold communications pursuant to attorney-client and work product privileges in certain circumstances where, it might be particularly helpful, or ambiguous as to whether that a privilege need apply in that scenario. So that was my only thought on potential future agenda items.
I will prepare them for your review for the next agendas.
Thank you.
There are also 2 files that have been assigned to compliance amendments that will be placed on our next agenda.
Okay. Thank you. And that concludes item number 6, unless Member Washburn has any comment on that?
I don't, no.
Item number 7, adjournment.
All right, motion to adjourn without objection. Can we take that without objection? All right.